So welcome to Should Judges Secure Unenumerated Rights from Lochner to Lawrence. For those I have not yet had the pleasure to meet, my name is Shannon Keene, and I am the president of the Federalist Society student chapter here at Brandeis. Thank all of you for coming again, and thanks to Dr. Pilon and Professor Marcosson for giving their time to discuss this issue with us today. Thank you also to David Willems and the entire Brandeis chapter of the ACS for co-hosting this debate with us. As with all of our events, we like to start with the Federalist Society's three main principles, and those are that the state exists to preserve freedom, separation of powers is central to our Constitution, and it is emphatically the province and duty of the judiciary to say what the law is and not what it should be. The structure for today will be as follows. David and I will take a minute to introduce our debaters. Then, starting with Dr. Pilon, each side will have 15 minutes to present their arguments. Following that, each side will have 5 minutes for rebuttal, and then we will open it up to the audience for a Q&A session. I will be keeping the time and let our debaters know when they have 5 minutes, 1 minute, and when their time is up. For rebuttal, I will let them know when they have 1 minute and then when their time is up. So we are incredibly excited to have Dr. Roger Pilon of the Cato Institute here with us. Dr. Pilon is the Cato Institute's Vice President for Legal Affairs, the founding director of Cato's Robert A. Levy Center for Constitutional Studies, the inaugural holder of Cato's B. Kenneth Simon Chair in Constitutional Studies, and the founding publisher of the Cato Supreme Court Review. Prior to joining Cato, Dr. Pilon held 5 senior posts in the Reagan administration, including at State and Justice, and was a national fellow at Stanford's Hoover Institution. In 1989, the Bicentennial Commission presented him with its Benjamin Franklin Award for Excellence in Writing on the U.S. Constitution. In 2001, Columbia University's School of General Studies awarded him its Alumni Medal of Distinction. Dr. Pilon lectures and debates at universities and law schools across the country and testifies often before Congress. His writing has appeared in the Wall Street Journal, the Washington Post, the New York Times, the Los Angeles Times, Legal Times, National Law Journal, Harvard Journal of Law and Public Policy, Stanford Law and Policy Review, and elsewhere. He has also appeared on ABC's Nightline, CBS's 60 Minutes, Fox News Channel, NPR, CNN, MSNBC, CNBC, C-SPAN, and other media. Dr. Pilon holds a BA from Columbia University, an MA and a PhD from the University of Chicago, and a JD from the George Washington University School of Law. Now, my good friend David Willems, president of the Brandeis ACS chapter, will introduce Professor Marcosson.
Thank you, Shannon, and thank you all for coming out today. I really think it's great that you take time out of your day, and I know you've got lots of other things to do, but I think this is a great issue. And when Shannon and the Federalist Society here brought it to me, I knew that it was something that we definitely wanted to be a part of. So we're really pleased to be here. Thanks to Shannon and the whole Federalist Society, and thank you to Dr. Pilon for being here today. It's so great to see you and to hear all of your great accomplishments. Hello, for those of you who don't know, my name is David Willems, and I am the president of the student chapter of the Louis D. Brandeis chapter of the American Constitution Society here at the University of Louisville. Now, my job is a little bit easier because many of you already know Professor Marcosson, but I'd like to begin by warning that Professor Pilon that if it comes down to a call on the basketball court, this could get heated. I had the pleasure of attending the first 2 rounds of the women's NCAA tournament with Professor Marcosson, and he's incredibly passionate about that. And so, you know, double dribble, fouls, whatever, it could get out of hand quickly. But seriously, Professor Marcosson is a 1986 graduate of the Yale School of Law. From there, he clerked for the Honorable George C. Pratt on the Second Circuit Court of Appeals. Then, he spent 8 years in the appellate division of the EEOC, the Equal Employment Opportunity Commission, briefing and arguing cases. He was instrumental in the implementation of the Americans with Disabilities Act when it was first enacted in 1992. Professor Marcosson has a long history of working tirelessly in the LGBTQ community, establishing, promoting, and protecting basic civil rights for this largely unprotected group within our society. In 2013, he began service on the Kentucky State Advisory Committee for the United States Commission on Civil Rights. Professor Marcosson teaches a variety of classes here at the University of Louisville, including employment discrimination, sexual orientation in the law, and of course, the aforementioned constitutional law and criminal law. He is an accomplished and prolific writer, a champion for civil rights, and a talented and engaging professor of law. It is my privilege to introduce Professor Samuel A. Marcosson.
Well, thank you, Shannon and David, and let me thank also Professor Marcosson for agreeing to participate in this debate, because as I said to him earlier, it's sometimes difficult for those of us who speak for the Federalist Society to get a local professor to come forward to debate or to at least comment. And it's always good when we do, because it tends to bring out more students. You like to see the give and take, and you're going to have it, I promise. Our subject is, as Shannon said, should judges secure unenumerated rights from Lochner to Lawrence? The answer, both Professor Marcosson and I have said, is going to be yes, where we will differ on what rights there are for judges to secure. And so I will take you through a quick history of the matter and then turn to the theory of it that is behind it. This issue comes to the fore because of the 14th Amendment especially, but there are also federal cases. But it's primarily as a result of the 14th Amendment, which was written to constitutionalize the Civil Rights Act of 1866. Unfortunately, in the slaughterhouse cases of 1873, the Privileges or Immunities Clause was eviscerated from the 14th Amendment, and we've had an uneven jurisprudence of the 14th Amendment ever since, dealing with what in the 20th century came to be called substantive due process. Now, one of the most recent cases that in which the court attempted to make sense of substantive due process, which I, by the way, am a fan of, was in the Glucksberg v. Washington case of 1997, in which he said that our substantive due process involves finding rights that are not enumerated in the Constitution, and to do that we take two steps. First of all, we try to see if the right is deeply rooted in the nation's tradition, and secondly, whether it's carefully defined. Well, the problem there is that he's got it backwards. You can't determine if it's deeply rooted unless you first carefully defined it. But if you've done that, even so, if it turns out that it is deeply rooted, then it probably is already protected, and if it isn't, it's probably not going to get protected. So that is no real theory of the matter. And so we're left with the problem of how it is we can develop a theory of the matter. You've got two dominant schools in this area. After the New Deal constitutional revolution, and the court finding its second wind in the 50s and 60s, the Warren and Burger Court, you had judges essentially engaging in what conservatives thought was judicial activism, finding rights that were nowhere to be found even among our unenumerated rights. That created a backlash among conservatives, starting with Alex Bickel at Yale Law, who was the teacher of Robert Bork in constitutionalism. And then you had conservatives calling on the court to secure only those rights that were fairly explicit in the Constitution, ignoring, therefore, the unenumerated rights that the Ninth Amendment speaks of and the Privileges or Immunities Clause. So you had two schools of thought, both of them wrong, I might say. Both of them made their peace with the New Deal's evisceration, the New Deal Court's evisceration of the doctrine of enumerated powers. The liberals, because they liked that new massive government that flowed from that, the modern regulatory and redistributive state, and the conservatives because they thought it was a lost cause. Where they differed was on the right side, along the lines that I just set forth. There has, over the 80s, beginning in fact in the mid-70s, a new school of thought, the libertarian or classical liberal school of thought, which I belong to, which says a pox on both your houses, both conservatives and liberals, and attempts to go back to the original understanding of the Constitution, the Madisonian view, as corrected by the Civil War amendments, which provides for limited government and maximization of individual liberty. So in order to develop a theory of the matter, what you have to do is go back to the beginning, and the beginning is not with the Constitution, but with the Declaration, which sets forth the philosophy of government. You look at Jefferson's discussion in the first paragraph. He puts us in the natural law tradition, the tradition that holds that there's a higher law of right and wrong from which to derive the positive law and against which to criticize it at any point in time. Nothing extraordinary about that. It's what the abolitionists appealed to, the suffragists appealed to it, the Civil Rights Amendment appealed to it when the positive law was thought to be unjust. And so you have to work out what this natural law theory is, more precisely the natural rights strain of natural law, which is quite different from the original natural law because it's not a top-down theory, it is a bottom-up theory drawing largely from the common law that evolved over some 500 years in England, which was drawn together by John Locke in the second treatise, which served as the template for Jefferson in the Declaration. And in the Declaration, when he speaks of, he does, first of all, state of nature theory, the idea being you want to set forth a theory that gives us what our rights are, absent government in a state of nature derived from reason, and where you run out of reason in areas such as risk, nuisance, remedies, and enforcement, you have to turn eventually to value, and therefore you have to move to out of the state of nature into government to address those problems where reason runs out of principles. And so when you do this state of nature theory, you work out your theory of rights, and it turns out the basic right is the right to be free, the right to be left alone, the right to against unjustified interference. And that's a general right which is good against the world, the basic right to be free to plan and live your life as you wish, provided you respect the equal rights of others to do the same. And then you come to the second great font of rights, contract. And the idea is that you can change the world of rights either through contract or by committing torts and crimes. And when you do, you extinguish or alienate old general rights and obligations, and you bring into being new special rights and obligations, special because they pertain only to the parties to the events that brought them into being. Tort or crime on one hand, contract on the other hand. And there's your building blocks for the theory of rights. Now, when you look at how this, we lived essentially for 150 years under this vision of limited government. It wasn't perfect, to be sure. The oblique recognition of slavery made necessary to ensure unity among the 13 states. The framers knew it was inconsistent with their founding principles. They hoped it would wither away in time. It didn't. It took a civil war, and the passage of the Civil War amendments, which for the first time provided for federal remedies against state violations of our rights and gave us the problem of determining what those unenumerated rights are pursuant to the 9th Amendment, which reads, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Notice, retained by the people. You can't retain what you don't first have to be retained. They were obviously alluding to our natural rights that we never gave up when we left the state of nature and entered into civil society. And so you come to cases like for example, Griswold v. Connecticut. There, the challenge to a statute that prohibited the sale and use of contraceptives. And you ask yourself, what right under the Connecticut police power is this statute securing? And you will come up empty-handed. No one's rights are violated by my selling you contraceptives or you using them. So the statute should have been found unconstitutional under straightforward freedom of association principles. It wasn't. It was found unconstitutional under this idea of privacy, the reason being that William Douglas did not want to speak of freedom, but of privacy, because he didn't want to have it zip all the way back to that hoary case of Lochner v. New York, which if you were taught by the average constitutional law professor, you learned was one of the worst decisions the court ever handed down. I am here to disabuse you of that miseducation. It was one of the best decisions that was ever handed down by the court. A pure case of freedom of association. Read David Bernstein's Rehabilitating Lochner, a wonderful book that lays out the whole story behind that case. And then when you get to cases like Lawrence v. Texas, you come to the same exact point. There, you've got a statute prohibiting same-sex sodomy. The original statute, by the way, prohibited sodomy, period, but the good burghers in the legislature of Texas realized that caught too many of them, and so they reduced it to same-sex sodomy. In any event, that comes before the court, and it turns out to be Justice Kennedy who comes up with a straightforward theory. He doesn't talk about whether this is a fundamental right or a non-fundamental right, whether the burden is upon the government or the burden is upon the individual. He says, look, this is liberty that's being restricted here. What's your rationale, the state of Texas? The best state of Texas could come up with is morals. Not good enough, says Kennedy. And so there is the way you want to go about it, at least at the state level. You look to the police power, which has as its fundamental purpose to secure our rights. It's the executive power that each of us enjoyed in the state of nature, the main power that we give up to government to exercise on our behalf. And if you take this approach, you will find a vast sea of legislation out there that should be found unconstitutional, that should never be passed in the first place. I give you the case that came out of Lexington, Kentucky, a local case. Time out?
5 minutes.
5 minutes. Oh, I got 5 more minutes. Fantastic. Maybe I was talking too fast. Okay. The case that came out of Lexington, Kentucky, just back in 2014, of a bunch of ex-college students who set up a moving company. Well, it turns out that they hadn't satisfied a certificate of convenience and necessity because a complaint was brought by another moving company in the area that there was no need for a second moving company. Can you imagine that? One moving company is quite enough. Well, they fought this, and it was decided surprisingly on rational basis grounds. In other words, the judge said, there is no rational basis for this. This is plain one competitor not wanting competition from another upstart in the business. And that was one of the rare decisions that has come down correctly. In fact, they now have a branch, this company does, here in Louisville called Cardinal Movers, and there are a bunch of ex-college students who are in the moving business. So keep that in mind if you need to move. Cardinal Movers locally, or it's the, what's the Kentucky team called? Wildcat Movers over in Lexington. Well, listen, I've covered enough for now. Even if I've got a couple of minutes, I will reserve my couple of minutes if I've got a couple, okay? And I'll turn it right over to Sam and ask him to have at it. We, as I said, will not disagree on a lot of things, but I'd be interested in hearing what he has to say to defend that hoary old case, Lochner. Whose rights were violated there? You look at the facts and you find out it was a sweetheart deal.
First, a bit of housekeeping. If you're in one of my classes, either criminal law or con law, there are the sign-in sheets over here. Could somebody pass them around now that we've gotten well into this, and just sign initial as you do in class as it comes around. Second, I do have to say that if there's any company that calls itself Cardinal Movers here and Wildcat Movers in Lexington, you should not patronize them because they are clearly trying to have it both ways, and that shouldn't happen. But that's a matter of choice and who you're going to patronize, and I think Mr. Pilon would concede or agree that freedom of contract goes both ways. And if you choose you don't want to contract with these people because of what they do in blue, then that's up to you. But first of all, I am thrilled that he's here and that we're having this event. And this is the kind of discussion that is, I think, enlightening and helpful in sort of seeing where there are areas of agreement between people who on many issues may disagree, and then also to explore the disagreements, but in a way that that is both civil and gracious, I hope. So as I say, we agree on a lot, and Roger pointed to some of those areas of agreement. We both believe that the Constitution protects unenumerated rights, and we both believe that Article III judges should enforce them. In addition, I think from what we just heard that we agree that a key foundation of those rights is the idea embedded but not entirely contained in the Constitution. That is, it comes from other sources as well, but it's in the Constitution. It's in the statements of the framers. It's evident in the historical experiences they were responding to. It is evident in the Ninth Amendment. All of this is that the protection of liberty is a, if not the, purpose of the Constitution, of a written Constitution in particular. We might disagree on whether it is the only purpose, that liberty is the only purpose, but we certainly agree it is an important purpose. I take it we also agree, although I'm not entirely sure about this because he talked about the Privileges and Immunities Clause and the slaughterhouse cases, which was the wrong turn, or one of the wrong turns the court took back in the 19th century. But I think we agree that the Due Process Clause is at least one font of those rights, a legitimate source of the court enforcing fundamental rights, the Due Process Clause of the 14th Amendment. Where we disagree, as he suggested, is in some of the specifics. Whereas I take him to be using the fundamental belief in liberty itself and limited government as the constitutional paradigms that judges should use in enforcing unenumerated rights, I believe that these are at most broad starting points, that it is critical to define the limits of the liberty that judges can enforce when it comes to unenumerated rights, that is, the space in which unenumerated rights operate. I think I can best explain what I mean about those limits by discussing what I think is actually the critical difference between Lochner and Lawrence. That is, between what I call the Lochner era of substantive due process and the modern era, because I think certainly Lawrence, as all of you who know me or have had my classes know, I think Lawrence was certainly rightly decided, but Lochner was quite wrongly decided, and the court's departure from the Lochner era in 1937 was one of its shining moments. In my view, the problem with the Lochner era is that the court sought to enforce unenumerated rights in the face of a clear constitutional authority supporting the exercise of the power that Congress was exercising, that is, the Commerce Clause. Now, Mr. Pilon and I disagree, I suspect, pretty fundamentally on the scope of Congress's Commerce Clause authority, although he talked about state regulations as well. I'm going to focus for now on congressional federal regulations. As I understand his writings, he believes that Congress has the power only to remove barriers to the free flow of commerce that states had been erecting, a protectionist view, protectionist laws during the Articles of Confederation. I have no doubt at all that this was, in fact, the primary evil that the framers were focused on and that they hoped Congress would deal with. But they did not limit the authority that they gave Congress to dealing only with that primary evil. And here I'm going to have the immense pleasure of being able to quote Justice Scalia. I always love to do that when I can. And he said this in a case called On-Call versus Sundowner. And it was a statutory case, but what he said about interpreting statutes applies equally well to the Constitution. And he said this: as some courts have observed, male-on-male sexual harassment in the workplace was assuredly not the principal evil that Congress was concerned with when it enacted Title VII, the whole idea of a principal evil. But statutory prohibitions often go beyond the principal evil to cover reasonably comparable evils, and it is ultimately the provisions of our laws rather than the principal concerns of our legislators by which we are governed. So the principal, what was the principal focus of the framers of the Commerce Clause, it may have been protectionist legislation, but what they gave Congress was the authority to regulate commerce. And that power is broad indeed, especially in a nation whose commerce in the 20th century is national in scope. And so, and Congress gets the right to determine, as a democratically elected legislature, what counts as something that impedes the flourishing of our economy. If they believe, if Congress believes that, and concludes on evidence that a regulation is needed to lift up the country's economy out of a depression, then Congress has that authority. And it is difficult to credit the notion that the principle of generalized liberty can be thrown up in the face or as an obstacle against an enumerated power of Congress. I don't think it's possible, or at least not persuasive, to say that a general principle of liberty can stand when the government is given, in this case Congress is given, a specific authority, in this case to regulate commerce. So the problem with the Lochner era, especially on the federal side, is that it applied a barrier against a specifically enumerated power given to Congress. So you can't just talk about unenumerated rights. You have to also ask, what is the government power, and does it give government the authority? Did the framers want to have the government to have a particular power? Under the Commerce Clause, in my view, they did. And if one of the critiques of the departure from the Lochner era was that this the substantial effects test that the court announced, that if any activity was seen to have a substantial effect on interstate commerce, that Congress could regulate it, that was made up out of whole cloth and grossly expanded Congress's power under the Commerce Clause compared to what the framers intended. But it didn't just come out of nowhere in 1937, the substantial effects test. Indeed, if you just read Gibbons against Ogden from 1824, Chief Justice Marshall should disabuse you of the notion that it was a brand new expansion of the Commerce Clause. This is what Chief Justice Marshall said in Gibbons against Ogden. Quote, "It is not intended that these words in the Commerce Clause comprehend that commerce, which is completely internal, which is carried on between man and man in a state, or between different parts of the same state, and which does not extend to or affect other states," emphasis on, and which does not extend to or affect other states, right? So the Congress doesn't have the power of something that's entirely internal as long as it does not extend to or affect other states. Such a power, he said, would be inconvenient and is certainly unnecessary. The genius and character of the whole government seem to be that its action is to be applied to the external concerns of the nation and to those internal concerns which affect the states generally. To those internal concerns which affect the states generally. What does Congress not have the power to do, Marshall said? Not to those which are completely internal within a particular state, which do not affect other states. The substantial effects test has been there all along. It was there long before 1937, and it was recognized as the power Congress was given. The reality is Congress slept on those powers for a very long time, and by the time the post-Civil War era came along, by the time the Lochner era came along, laissez-faire economics had risen up as the theory du jour, and the Supreme Court enforced it, thus limiting Congress's authority in a way that was not contemplated when the Commerce Clause was first passed. So my basic thesis is, if there is a specific power of government, then it's quite clear that the framers intended that not to be part of the zone of liberty into which government cannot intrude, and any argument based on unenumerated rights that would serve to limit an enumerated power of government has to fail. That argument has to fail. The modern era of substantive due process, that is, the fundamental right to privacy as emerging from the Due Process Clause, does not run afoul of a specific grant of textual authority to the federal government. For example, Windsor, United States against Windsor, in which the Supreme Court struck down one provision of the Defense of Marriage Act. To the extent, it's hard to tell when Justice Kennedy writes sometimes whether that was equal protection or due process fundamental rights jurisprudence, but to the extent that it relied on the idea of fundamental rights, Windsor stands on much firmer ground than any of the Lochner era cases, because there was no clear source of authority for government, the federal government, for Congress to be involved in that area in the first place. And if there's no express grant of authority, then the power, the right to liberty should have room to flourish. And the court properly strikes down such laws when it comes to substantive due process. For these reasons, I suggest to you that Lochner was, or the era that it defines, was not one of the best moments in the Supreme Court's history, and Lochner itself was not one of the court's best decisions. To the contrary, it was an artificial limitation imposed upon the powers of government. If we don't like what government does, if we think that government is intruding on our liberties in a way that is unjustified in how it uses its powers, our remedy is not for the Supreme Court to breach the separation of powers by stepping into Congress's realm. Our remedy is the ballot box. Our remedy is the democratic process that the framers established. Because they didn't just set up a framework for liberty, they set up a framework for governance. And that is our responsibility, not in cases where government actually has power to object and run to court to tell them how not to exercise it, but to tell ourselves to tell legislators or executives or city councils how they should be exercising those powers. So that's my view of it. I think there is a principled basis on which we can distinguish between the Lochner era, bad, and the Lawrence era, really good. And I look forward to hearing Mr. Pilon tell me all the reasons why everything I just said is completely wrong.
And I look forward to doing so. The thing that most surprises me about Professor Markusson's comments is that he focused largely on, he wanted to go after Lochner, but he focused largely on federal power. The problem there is that in the early decades of the 20th century, most of these cases were state cases. They weren't federal cases. And so it was not until the New Deal that the efforts of the progressives at the turn of the century switched from the state level to the federal level. And so I'll get to that in just a moment. But it looks like what he is trying to do is give us a rationale for the constitutional revolution of 1937, which I mean to dispel and leave nothing left of. The Revolution of 1937 took actually it was three steps. In 37, well, let's build up to it first. During the first 4 years of the Roosevelt administration, when the court found one program after another to be unconstitutional, after the landslide election of 1936, when all but 2 states went for Roosevelt, he, in early 37, unveiled his infamous court-packing threat, his plan to add 6 new justices to the Supreme Court. There was outrage in the country over that. Not even Congress in the House was 4-1 Democrat would go along with it. Nevertheless, the court got the message. There was the famous switch in time that saved 9, and it actually turned the Constitution upside down in 3 steps. The first, in 37, was to eviscerate the doctrine of enumerated powers, the idea that Congress has only 18 powers. You find that in the first sentence of the Constitution. All legislative power herein granted shall be vested in a Congress. By implication, not all power was herein granted. Look at Article 1, Section 8, and you'll see that it has only 18 powers. Look at the 10th Amendment, and you will see this spelled out explicitly. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people. In other words, the Constitution establishes a government of delegated, enumerated, and thus limited powers. So what did the 1937 court do? It took 2 clauses, the General Welfare Clause and the Commerce Clause, and that were meant to be shields against overweening government, and turns them into swords of government. Now, Professor Marcosson has focused on the Commerce Clause, so I will do so as well. He says that I would probably read it, as standing for only blocking barriers to commerce, something like is done today under the Dormant Commerce Clause. No, there is room also for taking affirmative measures on Congress to ensure the free flow of goods and services. Let's remember how the Commerce Clause came to be. It was because under the Articles of Confederation, states had begun erecting tariffs and other protectionist measures, and it was leading to the breakdown of the free flow of goods and services among the states. So they gave Congress the power to regulate or make regular commerce among the states. In other words, it was designed to be a essentially free trade principle buried right there in the Commerce Clause. It means there is some affirmative power to do things, like, for example, to give a uniform with respect to trucking across the state, so you don't have each state blocking interstate traffic. But it is not a power that to regulate anything that, quote, affects interstate commerce, which is exactly what the court did in the NLRB v. Jones and Laughlin in 1937, culminating with the bizarre Wickard v. Filburn case in 1942, whereby a farmer was prohibited from making. Oh, I borrowed 2 from the other. Yeah, 3 minutes. Okay, it was prohibited from growing wheat in excess of the amount allowed by the Agricultural Adjustment Act, when the wheat never even left his farm. And then that has led to such decisions as Lopez, where the court finally is coming to grips with this errant Commerce Clause jurisprudence. In 1995, that was the Gun-Free School Zones Act, when Rehnquist said, we start with first principles of the Constitution established as government of enumerated powers, and they found that Texas's statute criminalizing taking a gun to school was unconstitutional. That power belongs to the states. Morrison, we had the same thing in 2000. And then we had the Raich case, the California medical marijuana case, whereby Angel Raich grew the marijuana in her own home and never entered into commerce, much less interstate commerce. Nevertheless, this theory would allow, a la Scalia, to prohibit Angel Raich from using the only thing that would give her relief from the suffering that she had. And then we finally had in NFIB, that's the Obamacare case, the idea that you can use the Commerce Clause not simply to regulate commerce, but to compel people to enter into commerce, so that therefore the federal government can regulate. This is pure hocus pocus. The framers had nothing like this in mind. I could go on with other cases, but I'm going to end with a couple Scalia. I'm going to give you Scalia, and then I'm going to give you some quotes. Scalia said, this was Truxell v. Granville, the grandparent visitation state case out of the state of Washington, which authorized grandparents and others to go into state court and get an order to allow them to visit the the children of parents who may not wanted them to visit them. And Scalia said he would uphold this statute, which was the court fortunately found it unconstitutional, because he said the Constitution, the right of fit parents to control access to their children is a right that is now 1 minute. Okay, it is a right that is found in the Declaration of Independence, and it's one of our unenumerated rights. But he continued, the Ninth Amendment does not authorize him to say what those rights are or to enforce them. Well, the problem is he's drawn a sharp distinction between enumerated and unenumerated rights, the implication being that for 2 years, when we didn't have a Bill of Rights, we had no rights against the federal government. This approach is nonsense. Let me give you 2 quotes which will put to rest the kind of thing that this was a perfectly legitimate revolution in 1937. FDR, writing to the chairman of the House Ways and Means Committee in 1935, I hope you will not allow any reservations about the constitutionality of this bill, however well-founded, to stand in the way of its passage. Here's Rexford Tugwell, reflecting on his work some 30 years later. He was one of the principal architects of the New Deal and this massive government that Sam is upholding. In order to get our programs through, we had to engage in tortured interpretations of a document that was intended to prevent them. The New Dealers knew exactly what they were doing. They were turning the Constitution on its head in order to make the world safe for the programs of the New Deal. And with that, I rest my case.
I'd like to just focus on a couple of things to finish off before we start taking questions. One of those is notice that Roger did not address Chief Justice Marshall's language from Gibbons against Ogden about the scope of the Commerce Clause, as the idea that the substantial effects test came out of nowhere and had no history, no basis in the Constitution or in the scope of the Commerce Clause, that it came out of nowhere in 1937 is simply not true. It is belied by what Marshall said in Gibbons against Ogden, and the fact that Congress didn't then exercise that power much for the next century, and when it did only in the late 19th century and early 20th, those occasional forays were struck down, tells you that it was that court, the Lochner court, that was departing from the wisdom of Chief Justice Marshall's understanding of the Commerce Clause. Second, it is true that much of the Lochner era, as Roger suggests, was focused on cases of state power, state exercises of regulatory power, whether they be minimum wage laws, working condition laws, et cetera, not federal. And I focused primarily on the power of Congress under the Commerce Clause. The reason I did that was because I believe it's even tougher to make the case for Congress, and that it's easier on my side to do it for the states, because the idea that the framers of the Constitution wanted to limit, the original framers who wrote the Ninth Amendment and who had these ideas of liberty from the Declaration of Independence, the idea that they wanted to limit the states is completely non-credible. They, in fact, wrote the document. We know from Barron against City of Baltimore. We know from the Federalist Papers that they believed that the Constitution was there, with very, very limited exceptions to a couple of provisions, to limit the federal government. The Bill of Rights limited only the federal government. The states would be free. They were limited by what was contained in their state constitutions. It wasn't until the post-Civil War amendments that that changed. So if we're talking about what the original unenumerated rights could be said to protect, they certainly couldn't protect against state regulations, state intrusions. So it seems to me that that deals with that issue pretty effectively. Next, Roger suggests that, yes, Congress can take affirmative actions, that they're not limited to the dormant Commerce Clause sort of idea, but still, it didn't change what I said, which was that the scope of that power, even to take affirmative steps, had to be limited to, quote, ensuring the free flow of goods and services. So any other regulation of commerce, if in the view of the Supreme Court, their policy prescription was that it would interfere with the free flow of goods and commerce in some way, that Congress couldn't do. And I believe that's what he means by his discussion of Wickard and Gonzalez versus Raich. It is one of the most challenging things for a person on my side of this discussion to defend Gonzalez against Raich. But think about this. It is true as an empirical matter that when you grow a crop, whether it's wheat in Wickard or pot in Gonzalez, even if it doesn't enter into the interstate market, it creates more of that product. And when you create more of that product, you change the supply and demand. You can have bleed over into the interstate economy. If we don't like those regulations, if we think they are ill-advised, if we think they are harmful, if we think, you know, my mother suffered from multiple sclerosis for the last 25 years of her life. She used pot. I would be the last person to say we should have laws against medical marijuana at the state or federal level. The way to change that is to convince our legislators that these are terrible, ill-advised laws. The difference between us, and this is a cheap shot, I will admit, right before I even say it, is that I believe in democracy and he doesn't. I believe that we can change the things that when the exercise of a power of government is bad, is harmful. The way to deal with that, in the circumstances at least that we've discussed, is by changing those people who are exercising those powers badly. It's not to deny that the powers exist. And if that's not a sign of something, I don't know what is. 1 minute. And so I will leave it at that. And I hope that you will ask questions that challenge both of us. No home court advantage here. And again, I want to thank Roger for being here for a terrific discussion. Thank you.
All right, we're going to open it up to the audience for Q&A, and just so you know, I will repeat your questions so that those who may be watching on the stream can also hear. So Hobbes' social contract, does that create a slippery slope?
I'm not a Hobbesian, I'm a Lockean. But to your point about the social contract rests upon the issue of consent. And you do your little thought experiment on consent and you find that it doesn't justify much at all. First of all, the idea of to get out of the state of nature, you have to move from the individual right to self-enforcement to the collective right. Majoritarianism will get you there. You never get majoritarianism. Social contract theory is a two-step theory. Majority in the beginning to be bound by the, unanimity in the beginning to be bound thereafter the majority. That won't work because most of us, none of us, was there in the beginning. Third, you resort to tacit consent. You stayed, therefore you're bound by the majority. That's nothing more than the majority putting the minority to a choice between two of its entitlements to either to stay where, either to leave or to come under the will of the majority, precisely what the majority must have to justify on pain of circularity. And so when you do this little thought experiment, what you come up with is the idea that government per se has an error of illegitimacy about it because you cannot satisfy the fundamental criterion. That gets me to the last cheap shot that came in from Sam, namely, I do favor democracy for sure, but I also favor keeping most things out of the hands of the people and leaving it with people in their individual capacities. When we turn so much, as we have today, over to government, everything from health care to daycare to housing to jobs to on and on and on, we are on a slippery slope toward Venezuela, because what we find is that people demand far more goods and services from government than they're willing to pay for. So we go into debt. Today, the federal government has a debt of approaching $22 trillion. Nobody knows how we're going to get out of it. It's doubled in the last 10 years, and that doesn't account for the vastly larger unrecognized debt that is out there. It's no accident that Puerto Rico went belly up, that Detroit went belly up, that Illinois has a rating just above junk status. This is the result of democracy run amok. And you people are paying for it, by the way, because I hope none of you expects to retire on Social Security. It started out with 16 contributors to every recipient. It's down now to 3, and it's going in the wrong direction. So you better wake up, because you're the one who's paying for folks like me. Thanks a lot, by the way.
I do want to just say one thing about that. There is a solution to that. There is a solution to that, and that is go make some babies, right? If young people would just procreate more, we would have a baby boom. We would baby boom our way out of the Social Security conundrum.
You're getting into tricky territory there.
All right, yes, in the back.
Professor Marcosson, you mentioned Wickard and how Chief Justice Marshall essentially described the precursor to the substantial effects test. But that still does, wouldn't you say that, or could you not say that Chief Justice Marshall pulled back out of thin air almost, that before that case, where would the effects doctrine?
So the question was, the precursor to the substantial effect test wasn't that pulled out of thin air, correct? Is that what your question? Okay.
Well, you could argue that. There's two answers to that I would give. One is I'm willing to stand or fall on the mountain with Chief Justice Marshall. That's one answer. The more substantive answer is that I think it was a proper interpretation of both the Commerce Clause and the proper approach to interpretation of the document. As Marshall himself said in another case, don't forget it's a constitution that we're enforcing, designed to last for the ages. And his vision was that the Constitution, where it conferred powers, that those powers should be construed robustly so that government could function, so that it could, as circumstances changed, as the nature of the national experience changed, that the commerce power would shift along with those changing circumstances to last for a long time. If you have a static interpretation of the Commerce Clause power such that it is frozen in amber and applies only to the narrow subject that maybe was the framers' primary intent, then the Constitution can't deal with changed circumstances, with the economy growing into a national economy to a much greater degree than it was in the 18th and early 19th century. So I think Marshall's approach was right. There's many statements from the framers of the Constitution indicating that they wanted it to be interpreted in a way that would be flexible, that would allow for growth of the document along with changing times. And so it seems to me, although it seems like a contradiction in terms of there's some tension, that the original understanding of the framers was that there would be flexible interpretation of the powers. And so I think it is both originalist and adaptivist to take the view Marshall did.
The problem with that approach is that it is inconsistent with the original vision of the founders right up until the 20th century. When you read the Commerce Clause and the General Welfare Clause as authorizing the modern regulatory and redistributive state, you have literally ended the idea of limited government because there is no end to that. The Commerce Clause, if it's read to allow you to regulate anything that affects interstate commerce, there is nothing that does not at some level affect interstate commerce, so you have an open sesame to unlimited government. The founding generation would never have ratified it if that's what their understanding was. Indeed, there were two schools of thought, and when you read the Federalist Papers, there are the authors of the Federalist Papers who were trying to convince the anti-federalists that this government is not as expansive as you think it is. So in other words, you've got the limited government people, the Federalists, and you've got the even more limited government people, the anti-federalists. There wasn't a big government person in the bunch.
Yes.
Can you speak up?
I'm going to pose a rather cynical view of the current state of the government. That perhaps the people are failing the government as they currently stand and are not afforded any sort of remedy to fix it. So, and I was curious as to what would be a solution for the people at this point in time. So I suggest that if the body of government is interpreted or in a use analogy to a literal body and people being the legs supporting it, the legs have essentially been wiped out post let's go since 9/11 with the massive expansive powers that the executive branch have.
So
Yep.
people failing the government, what's the solution for that?
You're far from cynical. You're absolutely right. The people are failing the government in the following sense. Constitutions are written to discipline not simply the rulers, but the ruled. Federalist 51. When the rulers respond to democratic demands that are leading us to massive government, then discipline that is meant to be secured by a constitution goes out the window. And that's where we are today. Look at Bernie Sanders. The number of things that he wants to have would bankrupt us very quickly, not far in the distance, but very quickly. And all we have to do is look at countries like Venezuela, where the 2 presidents in a row have promised heaven and given us hell. People are starving to death in Venezuela as a result of this approach to government.
Well, my answer to that is there's some agreement. I don't think it's necessarily cynical, but we agree that there's a bleak outlook. I think what we disagree with is what we identify as the bleakness or the nature of the bleakness. I don't think the problem is massive government, although I think there's exercises of government power that are deeply problematic, as you identify the authorization of and exercise of powers that infringe on liberty when it comes to national security is a good example. But I think the much deeper problem, the much more serious problem we face, and it is attributable in large, although not exclusive part, to the people, is the dysfunction of our government and how systemically the Congress has become basically incapable of operating for different reasons, the Senate and the House, but both incapable of operating. The extent of political polarization that is paralyzing our politics in the country. I think there are various reasons to be deeply cynical, but the size of the government is way down the list, in my view, of the reasons to be pessimistic about at least our short and medium-term future.
Okay, we have time for one more question. Yeah.
Just one more? I thought we could go to 1:30.
We have to head over to.
Oh, we do?
Yes.
Okay. I'm enjoying this.
Dr. Pilon, in your opening remarks, you discussed the maximization of individual liberties.
Yeah.
So if you're praising Lochner, decisions like Lochner, and putting down Roosevelt revolutionary ideas, how else is the individual supposed to achieve liberty in light of the political giants of the common times? What is the Federalist view of that individual being able to stand on its own?
That's what markets are for. And one of the dirty little secrets about the progressive era, and Richard Epstein has written this in his wonderful book, How Progressives Rewrote the Constitution, which we published and I edited. One of the dirty little secrets is that the progressives, ended up extinguishing markets in wide areas and producing cartels. And that's just exactly the kind of thing we don't want, because it minimizes choice. The reason you can have individual freedom in markets is because you have a range of choices, which means that, for example, I am in favor of antitrust legislation when it is called for. But that's an open question, just when it is called for. But so I'm not an absolutist when it comes to the regulatory world. But the regulation, as I said earlier on in response to Professor Markuson's discussions of the Commerce Clause, is that it is designed to afford government affirmative power when it is exercised in order to ensure the free flow of goods and services among the states. And there are lots of cases where this can be done. Lochner was not one of them. This was a sweetheart suit which was brought by the bakers and the owner in order to overturn. Because what was going on in Lochner? Does anybody know the facts of Lochner? Why was this statute passed in the first place? Anybody know? It was brought to Albany by the large unionized bakeries in New York to protect them from competition from the small mom and pop bakeries. They couldn't take the heat from them, so to speak. And the bakeries that were employing immigrants just off the boat. In Lochner, these people were sleeping in the bakery. That's why they were there for more than 12 acres. While the bread was baking, they were sleeping in the bakery. And so here we have in Lochner a perfect case of public choice economics at work. You've got large unionized bakeries getting a law passed to protect them from competition from the small operations, which always have difficulty dealing with legislation unlike the big things. And what do we have from Caroline Products? The other great case that gave us a bifurcated theory of rights and a bifurcated theory of judicial review. We have the great filled milk case. what we have, Owen Fisk, who maybe taught Sam at Yale. He did, yeah, I figured. He said that Caroline Products, 1938, was the bedrock of modern constitutional law. This distinction between fundamental and non-fundamental rights, strict scrutiny, and rational basis tests, so that you can allow massive regulation to pour through. What was that case about? The filled milk case. One part of the milk industry went to Congress to protect it from competition from another part of the milk industry. It was a federal level issue, similar to Wildcat Movers over in Lexington. The more things change, the more they look the same.
Well, there's a lot there. Even if I were to agree, which I don't, but even if I were to agree, first of all, yes, Owen Fisk did teach me, he taught me procedure of all things. But anyway, even if I were to agree that the Commerce Clause authority is limited to only allowing regulations that remove barriers, Congress to affirmatively step in and remove barriers to the free flow of goods, Congress should have at least some discretion over, free from judicial oversight, to decide what is necessary or what constitutes a barrier to the free flow of goods and services. If, for example, they think that low wages or union busting prevents the production of goods or prevents the free flow of goods, that may be a new condition that didn't exist in 1790. A new economic circumstance that makes the economy not flourish, that prevents goods from being produced in the first place, or people from being able to earn enough of a wage to buy goods, and thus impedes the overall interstate economy. The challenges to the interstate economy don't remain the same over generations, over centuries. And if the interstate economy can be impeded by regulatory barriers erected by states, thus necessitating the dormant Commerce Clause, or giving Congress the power to stop in and tell the states to cut it out. It can also be impeded by the conditions of the market, by the conditions that affect workers, by the conditions that affect consumers, and those new challenges, if the Constitution is to remain relevant in a modern society, those challenges must also be subjected to congressional power under the Commerce Clause. And I think that's the area of fundamental disagreement. What represents Congress's true power, even though we agree, ultimately, that unenumerated rights, where there is not a power that can serve to block them or to limit those unenumerated rights, we agree that unenumerated rights exist and should be enforced, but we disagree on the scope of legislative power that courts should not limit.
Let's give our debaters a round of applause.